Hello and welcome everyone. Happy International Data Privacy Day and welcome to our virtual Privacy at Michigan keynote. I'm Florian Schaub. I'm an assistant professor in the School of Information here at the University of Michigan. And yeah, it's my pleasure to welcome you here. And I'm excited that you decided to join us to celebrate Privacy Day. Privacy Day is celebrated every year on January 28th. And the goal is to draw awareness to privacy issues and celebrate successes and solutions when it comes to protecting people's privacy and data. And today's virtual keynote is part of a month-long celebration of Data Privacy Day organized by Information and Technology Services and the School of Information. And it's also part of the Dissonance event series. So if you've been following along, we had a discussion on privacy awareness in higher education earlier this month. We've a couple of PhD students from my lab, the Security, Privacy and Interaction lab, have been hosting a series of online self-defense workshops. And yesterday we had one on protecting your privacy. Next Thursday, there's still going to be another one on protecting yourself against bad actors. And today we have our keynote event, which is going to be Beyond Privacy, Fairness and How Personal Data is Used in Our New Digital World by Dr. Gabriela Zanfir-Fortuna. And I'm very happy to introduce our keynote speaker today. Dr. Gabriela Zanfir-Fortuna is the Vice President for Global Privacy at the Future of Privacy Forum, where she leads work on global privacy developments and counsels on EU data protection law and policy. And she's working with all FPF offices and partners around the world. Gabriela currently serves as the member of the reference panel of the Global Privacy Assembly, and she's also a member of the executive committee of the ACM FACT Conference, which stands for Fairness, Accountability, and Transparency. She's a guest lecturer on global privacy at the Maastricht University, as well as an associate researcher with the Law, Science, Technology, and Society Center at Vrije Universiteit Brussels. As a data protection and privacy law expert, Gabriela has testified for the Federal Trade Commission on data portability and for the European Parliament's LIBE Committee on the EU's proposed Data Governance Act. Prior to moving to the US in 2016, she worked for the European Data Protection Supervisor in Brussels. She was part of the team that advised the EU legislator on the Gdpr during its legislative process. She has dealt with both enforcement and policy matters, was a member of the EDPS litigation team, and appeared before the Court of Justice of the EU. She worked on the assessments of both the draft EU-US Privacy Shield Agreement and the EU-US Umbrella Agreement during her time at the EDPS. And Gabriela holds a PhD in law from the University of Craiova with a thesis on the rights of the data subject. So as you can hopefully tell from all these credentials, Gabriela is amazing expert on global privacy, and it's my absolute pleasure to have her here today. And I'm excited for your talk, Gabriela.
Thank you so much, Florian, for such a kind introduction, and thank you for the opportunity to address your audience at the University of Michigan on Data Privacy Day. I like to think of myself as being a data protection geek. I always see myself like a data protection geek, and I think this is why I was able to do all the things that I did and all the things that hopefully I will continue to do in the field. And this is also why I want to start my talk today by reflecting on why today we are celebrating the Data Privacy Day, the International Data Privacy Day. Well, we are doing this because it marks the anniversary of the opening for signature of Convention 108, which still is today the only international treaty for the protection of individuals with regard to automated processing of personal data. And this convention was opened for signatures in 1981 by the Council of Europe in Strasbourg. It has 47 member states of the Council of Europe parties to the convention. However, it also extended beyond the borders of Europe and the Council of Europe. And now 55 countries have signed onto it and ratified it, and the other countries outside of the Council of Europe that have done so are Argentina, Burkina Faso, Mauritius, Mexico, Morocco, Senegal, Tunisia, and Uruguay. So this convention has certainly the interest of many jurisdictions around the world. But the fact that it was signed, it was open for signatures in January 28th, gave us the opportunity to reflect more broadly on the role of data protection and data protection law in today's society. And these days we're celebrating the Data Privacy Day just to bring this important topic into light. So you saw that this convention referred to the protection of individuals with regard to processing of personal data, automatic processing of personal data. It did not have the word privacy in it. And this is not by chance. It is because data protection law actually is a different type of law, and it has a different underlying principle than privacy. And this distinction is more difficult to be done here in the United States. However, in the European Union, where this distinction actually emerged, things are a bit more clear. And I'm hoping to be able to explain why the two are different a bit with my talk today. So data protection as a separate right has as its purpose dealing with the manner in which personal data are being collected and used. It actually presupposes that data is being collected and used, and its ultimate purpose, it's not to forbid such collection. It actually has as purpose to provide rules of the road for how we use personal data. It just wants to make sure that the way in which personal data is accessed, it's stored, it's processed to result into something else like a profile or into an automated decision is done by following principles and safeguards and rules that actually ensure that fundamental rights of the individuals are being respected. So it is built on principles such as transparency, processing of personal data, the way they're collected and used should be transparent towards the individual. It's built on principles like fairness, like lawfulness, accuracy. So the data that's being collected and processed should be accurate. Purpose limitation, the data should be collected and used for the specific purposes that it was initially collected for and for compatible purposes down the line. Data minimization, well, which technically means that we should only process the data that are needed for a specific purpose and not cast a very broad net, wide net to collect all the data that is available out there because maybe sometime in the future it would be useful. Individual control is also key to data protection. This is why we have rights of access, rights of erasure, of correction, the right to object to certain processing, and the right to portability. All of these features that I mentioned until now, perhaps with the exception of portability, can actually be encountered in most of the comprehensive data protection laws out there in the world. They're not solely relevant for the GDPR and for the European Union framework. Data protection is also about accountability because it requires those entities, those actors that actually are custodians of data to keep records of processing most of the time, to do a data protection impact assessment, to deploy data protection by design, to maybe assign a data protection officer or a privacy officer that spends their time and energy making sure that the organization is accountable and complies with data protection law and respects the rights of individuals once personal data is being processed. So this accountability set of the right to data protection is part of, I would say, some new generation type of provisions in data protection law. All of them can be found in the GDPR. They can also be found in some of the new modern data protection laws around the world, like the Brazilian LGPD, but not in all of them. However, accountability is an important part of data protection. Whereas when we're talking about privacy in this field, primarily, I'm thinking about privacy as a shield that protects a personal sphere, intimacy. It protects communications between individuals. It protects privacy life. So the type of safeguards it has in place are usually negative obligations, in the sense of not allowing this shield, right, to be touched. So this is why privacy usually has as its goal to perhaps not have, personal data collected and to just protect that sphere of intimacy. At least this is the theory beyond why data protection and privacy are different. And this is why at the very beginning, when data protection law started to be thought about as a distinct field, and that was in the late 60s and early 70s, primarily in the United States and in Western Europe, we've seen that the provisions and those safeguards that I detailed earlier have started to be crystallized and have started to make their ways into legislative reports and into initiatives at that time. One very significant report, and for those of you that are passionate about the field, I would highly recommend to give it a read. It's the Records, Computers, and the Rights of Citizens report that was adopted in 1973 in the United States, and that technically theorized and proposed the fair information practice principles, many of which are to be found in those core safeguards of data protection law I detailed earlier, and that had a huge impact for the development of data protection legislation in Europe, but as we see also now across the world. And I urge those interested in data protection to read this report because it's enlightening. It actually shows us why, at that point in time, lawmakers, decision makers, people that were thinking about these issues thought that we need some safeguards in the way in which computers that were just starting to emerge were collecting individual records. And one line from the mandate that created this special commission to draft this report for the Health and Education and Welfare US Department said that there is a growing concern that automated personal data systems present a serious potential for harmful consequences, including infringement of basic liberties. So this was one of the reasons why this commission was put together, to think about the type of safeguards that would be needed in this new world where we had automated personal data systems. The same report refers to the fact that this report, once drafted, it will help to assure that decisions about individual citizens are made on the basis of accurate, up-to-date information, and demands a hard look at the adequacy of our mechanisms for guaranteeing citizens all the protections of due process in relation to the records we maintain about them. So as you see, from the very beginning, this field was thought about because there were safeguards needed to protect individual rights and basic liberties in the face of computer power that was beginning to be more and more prominent and to be significantly developing, that relied on individual records, how they were called in this report. So this type of thinking is what actually prompted the appearance of the first data protection laws. At the same time in Europe, we had the Younger Committee in the United Kingdom that was doing a very similar work. And I think the two committees were actually communicating a lot with each other because their reports are fairly similar in terms of their conclusions. In 1970, we already had the first data protection law in the land of Hesse in Germany that had some elements of individual rights already, and some of these other elements specific to data protection laws. And then in the 70s and 80s, most of the Western European countries adopted comprehensive data protection laws on the same principles, based on the same principles: transparency, minimization, purpose limitation, individual rights, and that core of the rules of the road that I was mentioning. The United States, unfortunately, did not do that. There's an entire story there, and maybe once I come to Ann Arbor, we can have coffee and we can discuss about that in more detail. So this is why, and I really wanted to include a quote from Peter Hustings here. Peter Hustings is the first appointed European data protection supervisor in Brussels in 2004, I would say 2002, 2004. And he is an alumnus of the University of Michigan. So he has a special connection to Ann Arbor. And I was lucky to work at the European Data Protection Supervisor while Peter Hustings was in his last year of his second mandate as the EDPS. And Peter had framed very, very well why data protection has different goals than what we have in mind with privacy. He said that data protection was not designed to prevent the processing of such information, personal data, right? Or to limit the use of information technology per se. Instead, it was designed to provide safeguards whenever information technology would be used for processing information relating to individuals. This was based on the early conviction that the extensive use of information technology for this purpose could have far-reaching effects for the rights and interests of individuals. So you see, we're talking here about all of the rights and interests of individuals, and we're talking about safeguards that should be put in place for how personal data is collected, is dealt with, and is used by information technology in such a way that all of the rights of individuals are guaranteed. So the goal of data protection is to ensure that information relating to individuals is collected and used in such a way that all their other fundamental rights are protected. And there's not a finite list there. So we can talk about freedom of speech, including the right to privacy, the right to life, the right to security even, the right to non-discrimination, freedom of assembly, and the other fundamental rights. This is very important to keep in mind as we move forward in our data-driven world and societies. Now, it's not only Europe that's fixated on thinking about data protection differently than privacy. There are other constitutions that are starting to do so as well. So in the European Union, we have Article 8 in the EU Charter of Fundamental Rights, which was adopted in 2000 and became effective in 2009. That specifically addresses the fundamental right to the protection of personal data. And it's provided distinctively, separately than Article 7, which provides protection for the right to respect for private life and communications and family life, which is thought as covering privacy. Mexico also has amended its constitution in 2009 to introduce a reference to the right to data protection in Article 16. Brazil most recently, last year, towards the end of last year, has voted in the parliament, in the Senate there, to include a fundamental right to data protection in the Constitution of Brazil. In Kenya, I've seen a very interesting development, even though the Constitution does not specifically protect data protection separately than the right to respect for private life. Last year, the Constitutional Court there found that the digital ID scheme that was being proposed by the government was unconstitutional, breaching the right to respect for private life because it did not comply with obligations laid out in the data protection law that had just been adopted for the country. So we're seeing data protection as being considered as a fundamental value in today's societies in several different jurisdictions. And this is on top of the fact that many countries, and we'll see a map at the end of this presentation, have adopted comprehensive data protection law as part of their secondary law corpus. I want to focus now a bit on why and how is data protection relevant in the age of automated decision-making. I don't dare put here AI instead of automated decision-making, but especially because I do not pretend to know exactly how all different versions of AI exist. So I will refer to automated decision-making, but I want us to have in mind the complex processing that has to do with algorithms, machine learning as well, and different other versions and applications of AI that may be relevant for this. I will focus on the provisions of the GDPR because it's one of the most baked data protection laws out there. It comes on top of a long tradition of having data protection laws in Europe from the 70s. And this is why I chose it as the key case study here. I would say that the most relevant GDPR provisions, besides the fact that the GDPR is meant to be technologically neutral. So it's meant to apply regardless of the technology that appears, from the old computers that existed in big rooms in order to, just to be able to process a bit of information, to brain-computer interfaces. The GDPR does not care. So it applies equally to all technologies. But what it cares is that it applies to processing of personal data. And then it defines these two notions very broadly. So personal data technically covers any information related to an identified or identifiable individual. And then there are a lot of nuances. We're talking about the capacity of even singling out individuals. And it technically covers a broad array of information that is available out there. And then it also has a very broad definition of processing because it applies to any operation or set of operations performed on personal data, like collection, structuring, combination, making data available. All of these are offered as examples in the definition of processing. And there are many other examples offered there. But literally any operation or set of operations done on personal data as broadly described actually is covered by GDPR provisions. So this broad definition, and I'm not going now to enter into the personal scope and the territorial scope. We'll leave those aside for the time being. We're just looking at what the GDPR applies. Well, these broad definitions actually brings things like training of models for machine learning, things like facial recognition and collecting the information for that, things like algorithmic decision-making, any form of automated decision-making that rely on personal data somehow in that flux of how it works, even in mixed data sets. All of this is brought under the scope of the GDPR, and it triggers the application of all of its rules. And now I know that some of you here in the audience may be familiar with the fairness, accountability, and transparency community that has been building in the past years around specific uses of machine learning and in the computer science world, right? Well, fairness, accountability, and transparency are all principles under the GDPR in Article 6. They are technically legal obligations for whenever you process personal data. So this also shows how these two worlds collide, right? On top of this, the GDPR also includes a dedicated provision to automated decision-making. That's Article 22 of the GDPR, which says that individuals have the right not to be subject to solely automated decision-making that produces legal or significant effects on individuals. Now, this particular article was interpreted by data protection authorities as being a prohibition to engage in this type of solely automated decision-making. It's very important to keep in mind that in order for this article to be triggered, we need to talk about solely automated decision-making, so no relevant human involved there. That the effects of the decision-making have to be legal in nature or have to similarly significant affect the individual. And if all of these conditions are met, the only way to engage in this type of ADM is whether there is specific consent of the individual, or this type of ADM is necessary for a contract, entering a contract or the performance of a contract, or it is allowed by law. But all of these conditions will actually be quite difficult to be met. Specific consent, we'll see in some of the cases, is not possible to get if a meaningful information about the ADM and information about the logic involved in ADM is not disclosed to the individual, as an example. And then if this type of ADM is allowed under Article 22 and the specific consent contract or the lawful, the legal permission, the law permitting such ADM exists, then suitable measures must be implemented to safeguard the data subject's rights, so the individual rights. And these suitable measures are at least three. The right to obtain human intervention from the organization engaging in ADM, the right to express their own point of view, so individuals that are subject to this type of decision-making, and also the right to contest the decision afterwards. So at least these three safeguards have to exist in order for this ADM to move on. Now, I'm hoping to not lose myself into some of the cases that we've been looking at in the past year. So I'll just give you some examples, and then I'm really looking forward to engage with the questions and in the conversation with Florian. But I want to highlight that these are not dead letters of the law, neither Article 22 nor the principles here or the rest of the provisions of the GDPR. They have not been applied throughout the history of data protection law to a lot of automated decision making because, frankly, there wasn't a lot of it up until, let's say, 5 years ago, right? At least not in Europe. But we are starting to see more and more cases, and together with my brilliant team that's working on this, Sebastião Barros Vale and Caterina Demetso, my colleagues at FPF, we have been looking at case law in Europe that applies the GDPR to specific automated decision-making or algorithmic decision-making applications. And we were very curious to see whether this is effective. How do we apply data protection law to this type of processing? And I was happy to discover that it was effective. And I was not surprised because, as we've seen at the very beginning in the 70s, these were the main concerns: to protect the rights of individuals in the face of increased automated processing and automated decisions that would be taken in relation to them. So a couple of examples of the cases we've been looking at. As you can imagine, courts and data protection authorities in Europe are spending a lot of their brain power and time to understand what makes an automated decision to be solely automated. Does it suffice to have a person there to rubber stamp an outcome that an algorithmic program had? What does it count in terms of human intervention? They're also spending a lot of time to understand what does a legal or significant effect mean. They're also looking at those specific safeguards and how are they meaningful. They're looking at what meaningful valid consent means in this type of decisions. We were able to identify about 30 cases. We're working on a report and really hope to have it out fairly soon. And I'll give you a glimpse into some of those findings that we had. So we've seen, for example, that there were several cases where schools across Europe, from Sweden to Bulgaria to France, wanted to deploy facial recognition systems for different purposes, and of course, different type of facial recognition systems. For example, a school in Skellefteå in Sweden wanted to record the student's attendance to an exam by using facial recognition. This was actually deemed unlawful by the Data Protection Authority by following a complaint of one of the students or their parents. The DPA found that there was an imbalance of power between the school and the students when the school asked for their consent. So therefore, the consent was not valid and this system cannot be used. And the breach of Article 9 of the GDPR was found. In Article 9 protects sensitive data, including biometric data used for identification, and it has very specific rules for that. Then, as a part of the pandemic response, a school in Bulgaria wanted to introduce a facial recognition system at the entry into the school, together with a temperature measurement system. Now, it wasn't very clear for me if that facial recognition system was maybe not really facial recognition, but just facial identification. However, the Bulgarian Data Protection Authority decided that it was unlawful and did not allow the system to be put in place because, again, an imbalance of power. So the consent could not be considered to be valid. And they found that this was a type of solely automated decision system that has a significant effect on the individual. The consent was invalid, so it was unlawful. Also, a similar system, really automated facial recognition this time, wanted to be implemented in schools in south of France to grant and refuse access to people that entered the school and that were checked against the list of enrolled students and their images, and that as a result would be let to enter or not let to enter the school. Well, a court in the south of France found that this pilot project was unlawful. This was supposed to be implemented in Marseille and Nice. It breached Article 9 Gdpr, and it breached necessity requirements. The court made it clear that this goes too far because there can be other less intrusive means to achieve the same result. There are also a lot of cases of automated decision-making in employment in the labor law area. For example, we've found a case with the Data Protection Authority in Germany that did not allow a job application assessment tool that selected what candidates will be invited for interviews to be used by the Saxon State Chancellery. This is a case from 2019. The DPA found this job application assessment tool to be unlawful because there was no meaningful human intervention, and the selection for interview decisions were taken just as a result of this automated assessment. There are now a series of cases that look at food delivery apps and that look at the gig economy workers and how their work is being managed by automated decision-making and through algorithms. And these cases are really fascinating. There are several of them. For example, one in Italy against Deliveroo, a food delivery company, found that this company failed to systematically verify the accuracy and correctness of its automated rider management decisions, as well as the relevance of the data to the decision-making process with regard to how the riders are managed. So the Italian DPA found that there was a breach of Article 22, and in fact, this is a more complex case. There were several other breaches there as well. So the GDPR and its provisions are having a real impact also in this gig economy part of our new life in the digital world. There are many other cases, and I really don't want to bore anyone. I would point out, for example, that the Netherlands has a system to e-screen automatically applicants that want a gun license. And this system was challenged in court on several grounds, one of which was that it was solely automated and it doesn't have any sufficient safeguards. Well, the court in the Netherlands found that actually the pre-screening is not solely automated because there was an entire procedure provided by the law creating this pre-screening process that had the automated result of the pre-screening to be assessed by a team in the police department, in the relevant police department, and then to, on the basis of the assessment of that team, have a recommendation of whether a gun license should be issued or not. And then the chief of police also had to make a decision in this regard. So they found that the procedures and the processes in place were of such nature that this was not solely automated decision-making. Distributing benefits to job seekers. We have cases on that too. We have cases on student proctoring software as well, and also very recent because of the pandemic. And for example, in Portugal, the lack of clear human assessment criteria was found to lead to rubber stamping the algorithmic suggestions made by the proctoring software. Thus, the decision was solely automated and it did not respect the other conditions, so therefore it was deemed unlawful by the Portuguese DPA. I will conclude now. I want to have some time to discuss with Florian. I just want to point out that the map of comprehensive data protection laws is expanding. It's very big. We don't see the United States on it, unfortunately. So the countries here in orange are not countries that do not have a comprehensive data protection law in place yet. They only have sectoral regulations. But everything you see with blue has this type of law in place. This is a chart from the IAPP, and I invite everyone to either ask me for the link or look for it because it's a very useful tool. And all of these laws, especially the ones that have been modernized after 2018, inspired by the GDPR, or the ones that have been adopted, like even in China, China adopted it in August of last year, in August 2021. All of them have the same broad scope of application, have very similar principles, and it is to be expected that all of them are relevant in the ADM, AI, ML context. South Korea already had a decision last year. It was the first case where the Personal Information Protection Act was applied to an AI system. Our colleagues in Brazil are organizing a conference this summer, CPDP Latin America, on artificial intelligence and data protection in Latin America. So this certainly has, this field is certainly very rich, and the impact of data protection law is much broader than just talking about privacy. I hope you were able to get some interesting bits of information from this very long talk. Sorry about that. Florian.
I thought it was a very fascinating talk. I have lots of questions. I'm sure you and I could talk for like the next 5 hours if we had the time. Let's maybe start with one of the questions that came in through the Q&A, which I think can lead us into a broader discussion, which is, why does the US doesn't have a law similar to those that exist in Europe? And let me add, like, in addition to that, which is, You started by talking about the US Departments of Health, Education and Welfare report from 1973, right? Which is kind of considered the birthplace, so to speak, of fair information practice principles. And we see these crop up and pop up in many of these laws you talked about, right? Gdpr is kind of like adopting them. Many of these other countries are adopting them. Even US laws, sectoral laws, have some of these principles, right? The Federal Trade Commission has its own version of the fair information practice principles. Given all of that, why do you think it's so difficult for the US to come to an agreement around a comprehensive privacy law on the federal level, let alone reconciling state laws or coming to international agreements?
That is a million-dollar question, I don't have a straight up answer, but I can give you some context and some background information on what's happening. And the truth is that what we're seeing now, it's really not unique in the history of the United States. So because we're seeing a lot of bills that have been proposed in the past 2-3 years in Congress, and none of them moving forward. But this is not really a symptom of the current days. So the reason why we don't see a comprehensive data protection law should be looked elsewhere, because back then in the 70s, and you saw that indeed the US did have the leading voice in trying to set up this safeguards, right? After that report was published in 73, there were a couple of bills introduced, but one in particular was introduced in Congress, which was incredible. And I'm going to share a link in the chat with everyone, because I looked at it in detail a couple of years ago, and I have a short blog about it. It just had so much in common with what we're seeing in modern data protection law. It's uncanny even. And it was applicable at federal level and at state level. It covered the public sector and the private sector. It provided for individual rights of access, even a form of a right of erasure. It had strict data retention limits. It was really very comprehensive, but it failed. And there's actually a report of about 1,400 pages with the discussions in Congress back then. In the end, that bill was actually trimmed down to only cover federal agencies. So it applies to federal agencies, but then it also, it was trimmed down also as well in safeguards. And now it's called the US Privacy Act of 1974, one of the old data protection laws around here. But to me, the fact that this effort failed also in the 70s shows that there must be something about, I don't know, American lawmaking that just does not work well with this type of legislation. I say unfortunately, but I self-proclaimed myself a data protection geek, so you'll forgive me for saying that. So I really don't know what the explanation is, but I think I still keep some hope, even if not in 1 year, even if not in 2 years, that the US, if not following this sort of trend that it started in the 70s, at least will propose something that's equally protective of civil rights and the fundamental rights in the face of this data and automated decision-making machine learning tsunami, because I think it's needed to have that type of safeguards. And maybe maybe this model just does not work with the US, but something needs to work, right?
Yeah, great point. I guess like one of the questions is also, do we even need a federal privacy law in the US, right? We've seen multiple states adopt comprehensive state privacy laws. California is kind of leading the way there. It's one of the largest states, one of the largest state economies. So many companies will comply with the California laws anyway. We see other laws in Colorado and Virginia and other places. do you think that's something to be happy about to see these state laws crop up, or do you think ending up with 50 different privacy laws is going to be problematic?
I am happy to see these state laws propping up, because from my point of view, some protection of your data is better than no protection at all. So to the extent that these laws at state level cover personal data and processing that is outside of the scope of any other federal law, I'm happy to see them. At the same time, the proliferation of different standards of protection of rights, literally, because we're talking about rights in the US, okay, civil rights, in Europe, fundamental rights. This really creates a difference in levels of protection of the rights of Americans. Like, why should Californians be more protected in their data rights than I'm not going to say Michiganian or Michiganders, but why? So I do hope that we'll see a federal standard. This is why I hope to see a federal standard, because if we leave it to the states, inevitably there are going to be differences in the level of protection, with some states maybe never affording such a protection to individuals. And then of course if you look from the company's point of view, having to comply with so many different 30-40 different state laws, it's not optimal.
Right. Yeah, and I think one other aspect that we can maybe transition towards is so the Austrian Data Protection Authority just ruled that Google Analytics violates the GDPR because data is being transferred to the US. The Norwegian DPA just adopted the same ruling. I think that came out today or yesterday. So can you maybe explain for our audience, like what are the underlying issues with it? Like why should we even care about EU-US data transfers, right? It's a very nerdy topic, big topic amongst privacy geeks, but most people are like, oh, right? What do you think is gonna happen next, right? Like are we gonna have a legal framework to transfer data between the EU and US, or will that only become possible once there is some kind of federal comprehensive privacy law?
That is $1 billion question, not even $1 million question anymore, because just so much hinges on it.
I'm just sending you the softballs.
Yes. I think it's very important to highlight that these decisions, they're targeting Google Analytics and the cookie used by Stripe in another case. But they're not really about how Google Analytics processes personal data or transfers the data to the US, or how Stripe is doing that, or how any of the companies transferring data to the US are doing things. What it is really about, it is the US laws in the national security area that were deemed by the Court of Justice of the European Union to not provide sufficient protection to European data when it travels to the United States, or when it is accessible, when it's made accessible from the United States, which also counts as a transfer. So the real issue with these cases is that after the Court of Justice of the EU made these findings in 2020 about Section 702 of the FISA Act, about Executive Order 12333 and Presidential Policy Directive 28, 3 specific legal acts, executive orders, one law, right? That grant national security authorities broad authority to access data that is available in clouds, electronic communications data, right? So after that finding was made, and the former framework we had in place to allow for transfers between the EU and the US Privacy Shield was invalidated because of that, we have not seen changes as of now in any of the 3 acts. The European Commission and the US government have been negotiating for a year and a half potential changes that would make the Court of Justice of the European Union reverse its decision. And they have not yet met in the middle, I would say. Just to be clear also about the specific findings of the Court of Justice, primarily it had two concerns. The first one was the lack of proportionality of accessing this data. So the data of non-US persons. So all of these laws in this particular scenario do not concern the data of US persons, which includes citizens and permanent residents. This is only about accessing data of non-US persons. So, like data of Europeans that comes into the US. The court found that there are not sufficient safeguards and that there is a sort of a bulk access to data, which is afterwards sorted. And when assessing that entire system, it thought that it's not proportional, and it does not meet necessity and proportionality as required by EU for a standard of equivalent protection to the one in Europe. That was the first issue. The second issue was that non-US persons like Europeans do not have the right to a judicial review, or actually not even judicial, they do not have the right to individual redress, effective redress, if they suspect that their rights were broken, were breached, sorry. They do not have effective redress, independent redress, to have their cases dealt with. And this is a big issue that actually puts the EU and the US on a constitutional collision, because if we want judicial redress indeed, and not other type of redress, and we're looking at the US Constitution and the rules on standing, we'll find that, not even US citizens have standing in some of these cases. And they tried, it's not that they did, they tried. So we have like a couple of cases that went to the US Supreme Court where American persons and NGOs tried to challenge the national security laws, but they did not have standing. So it looks like an impossible situation to solve, but hopefully it will be solved. I don't know how, but I hope to see it solved.
Yeah, thanks for that perspective. Let's shift gears a little bit. You talked a lot about automated decision making. I thought it was really interesting to especially see these different cases where this clause is being used to of the Gdpr is being used to kind of like curtail use of facial recognition, for example. Now this kind of demonstrates like that the Gdpr already applies to automated decision making. At the same time, there's a lot of talk about AI regulation, both in Europe, but also in the US and other countries. What's your perspective on this? Like, do we need additional AI laws? And if yes, what do you think they need to cover in addition to what data protection legislation can do?
This is one of the key questions that lawmakers are dealing with right now in those jurisdictions that are looking to adopt AI regulation. And I can already point out that the European Union has published a proposal for an AI Act. Brazil has published a proposal for an AI law that's more principle-based. In the US, there are several initiatives. There are some bills that are looking at automated decision systems, primarily at state level, I believe. So there is a lot of that activity happening now. But what I don't see a lot of, and this is what prompted the study that we're doing now with my team, is thoughtful reflection of how much of this is already dealt with by data protection law and other type of laws that we have in place, and how much of this is not, and where do we have room to come up with new rules for AI systems. And unfortunately, I have not seen a comprehensive analysis of that, and we hope that we can contribute to that with this work that we're doing. I believe that there are spaces and places where data protection law does not reach the risks posed by AI systems. And we should be very thoughtful on how to deal with those spaces. But at the same time, as we've seen, a lot of it is already covered, at least at this stage of some algorithmic decision making and some of the things that we're seeing deployed right now. And I really hope that everyone that's working on AI lawmaking will pay more attention to data protection. And I was happy to see our colleagues from Brazil doing this entire conference on the topic, because I think we really need this type of analysis.
Yeah, and I think it also goes back to one of the points you made early on in your presentation, how data protection is about adding protections to the processing of data, not necessarily preventing the processing of data, right? Whereas questions of privacy and privacy regulation should maybe address larger questions, right? Like what is desirable to automate or not automate. So yeah, I think so lots to talk about there in that area. We're almost at the end here, but I would be curious to hear, what do you see as kind of like the important privacy topics to watch out for in 2022 and beyond, given that the talk was privacy, beyond privacy?
Indeed. I would say that I think usually about this in two time frames. So the immediate time frame, I can already tell you that international data transfers and the other side of the coin of transfers, which is data localization, are absolutely top of mind, are the subject du jour, and you pointed out the series of cases that started to show up in Europe against Google Analytics. We're waiting to see where this entire conversation goes. We're waiting to see how the EU and the US are going to deal with this situation, because indeed, if we are to stop data transfers from Europe to the US, that would not be a pleasant outcome for anyone. And I can tell you already that given that all my family is in Europe, I really want to continue talking to them via online tools, so I wouldn't want to see a radical effect of this blockage of transferring the data. So that's absolutely top of mind. But then if I'm looking at the other timeline, so if I'm looking, 3 to 5 years on, I would say that the way we are applying these rules, and if we modernize these rules to automated decision-making and algorithmic decision-making and machine learning and facial recognition, is going to be crucial for civil rights and for fundamental rights and for societies and democracies in general. And one other thing that I'm looking at is the fact that we're starting to see a second generation of data governance laws appearing. As you see, I'm not even using data protection. Now I'm using data governance, because this is what we're seeing again in Brussels with something called the Data Governance Act that has the text approved and will very likely formally be adopted sometime in March. And that creates a notion of data intermediaries, talks about data altruism, and applies to both personal and non-personal data. So that's kind of the interesting trend I'm seeing. A bit of blurring the lines between personal and non-personal. And that's also happens with the Future Data Act in Europe. This is actually happening right now in India, where the Personal Data Protection Bill introduced in 2009 was just amended to refer to Data Protection Bill, because it will apply to both personal and non-personal data. So we're seeing a bit of this shift, and I don't know where it will go, but it's certainly interesting to follow.
Yeah, I think that's really interesting, right? Like ultimately, almost all data is about people at some level, somehow. Thank you so much for taking the time to talk with us about privacy today, Gabriela. I think I learned a lot. It was really great. Thank you everyone for attending today. If you want to stay up to date on the news and privacy, consider following Gabriela on Twitter at Gabriela Zanfir. All the privacy experts follow her to get privacy news about legal developments and privacy. So you might as well. And then finally, I want to thank everyone behind the scenes who has been working hard to put together the events this month, and especially Svetlana Sich, the Assistant Director of Privacy and IT Policy at the University of Michigan, who's really done a tremendous amount of work to bring these events to life. Thank you, everyone. Happy Data Privacy Day and happy 2022.